presentation set up. Yep. That's good. And can you guys hear me okay? Okay. My name's Hilly McGahan, and I'm the staff attorney with Safe Harbor. We have a legal program that's based out of Polson, and I work with victims of domestic violence, sexual assault, and stalking in state court, in the district court in Polson, and in tribal court in Pavlo. And I've been doing this work since 2012 when the legal program was with Doug's, and then we merged and became Safe Harbor, and I've been continuing to work with the legal program there. So today I'm talking about sexual assault, which is kind of a huge topic, and it's also a topic that I think creates a lot of discomfort, so I just want to acknowledge that up front. Because it's such a big topic and for our time constraints, I'm going to focus on giving an overview of just the definition of sexual assault and some sort of histories of sexual assault, and then I'll focus a little bit on sexual assault on tribal lands and on campuses, and some background of Title IX and some of the things we may have heard about in the news with recent campus sexual assault crises. So we can just start by looking at legal definitions, which are quite general and don't, I think, help us out a whole lot until we really start talking about how we got to this place. But Montana law defines sexual assault as a person who knowingly subjects another person to any sexual contact without consent. And the Confederated Salish and Kootenai Tribal Code defines sexual assault in almost exactly the same way. And then I've also included a more general Title IX definition, and we'll talk more about Title IX when we talk about campuses. And they define sexual violence and all of the different acts that fall within that more general definition. But all of those criminal definitions really involve an abuse of power carried out as a sexual crime. And I think that's really important to remember throughout. I'm also going to be talking today, I'm basing a lot of the tribal history and then the modern day tribal issues with rape on the studies of a woman named Sarah Deer, who's an attorney. She's from the Muskogee Nation, and she practices in Minnesota, and she recently got a MacArthur Genius Fellow for a fellowship for her work on the Violence Against Women Act, and she wrote a really important book that just came out called The Beginning and End of Rape: Confronting Sexual Violence in Native America. And so I reference her studies throughout because I think it's the most current and important studies that we can be looking at right now. And so she provides an indigenous theory of rape in her book, and how that's defined as the unlawful invasion of the body, mind, and spirit. And I think that holistic look at sexual violence is also really important as we think about the situation of Native women right now. And I always think it's important whenever we talk about kind of a modern day crisis to understand, and I won't go way deep into history, but I think that we need to do a brief history so that we see how we got to where we are now, because it really helps to understand why we're dealing with the sexual violence that we're dealing with. And I also just want to say before I start that I am going to be talking mostly about gender-based sexual violence, and by that I mean sexual violence perpetrated by men against women. But I do not want to minimize the very real sexual violence that's happening in prisons, in churches. We have all heard about the Catholic Church and the sexual abuse that has happened, and I think it's really important that we understand that that's happening and that there's a lot of abuse in same-sex couples. And so I don't want to minimize or act like that's not happening, but I'm going to be focusing on gender-based sexual violence because by and large it's what we see perpetrated in the context that I'm going to be talking about today. And it's also it makes up the largest percentage of sexual violence that is happening. So looking at American rape law, which is based off of English common law that we inherited from the settlers who came over from Europe to the US, it's really important to understand that that law that we have based our modern day rape law off of defined women originally as property. And so we all know women couldn't vote, women were not treated as their own legal entities. And so sexual violence laws, starting back from the beginning of our country, actually treated sexual assault as property law. It was an offense against either the husband who owned the wife or the father if the young woman was unmarried. And so understanding why we're maybe having some problems with our laws in this area, that's kind of a helpful sort of thing to look back on as the source of sexual violence laws in America. And so sexual assault was in fact considered a trespass against property and not a crime against a human. I think it's also really helpful then to compare Anglo-American rape law to what was going on in tribal communities in this country before that set of laws was imposed upon tribal communities. And here I draw heavily from Sarah Deer's book, and I will kind of echo what she says, which is I don't want to generalize all tribal communities in the US, and I don't want to romanticize sort of some of the matrilineal setups that we know that a lot of these tribes had, but there are some generalizations that Sarah Deer has identified among all of these tribal societies, and so I just want to touch on a couple of those. So as opposed to women in Europe who came over under those Anglo-American laws who were treated as property, Native women had spiritual, political, and economic power in tribes, in every tribal society that was studied by Sarah Deer and by many other people who know their tribes' histories. And women and children were just not considered the property of their husbands. Also, pre-colonial tribes exercised full jurisdiction over crimes of sexual violence within their own communities. And that's really important because that's going to come up today with why we're seeing some huge crises of sexual violence perpetrated against Native women by non-Native perpetrators. So because in these pre-colonial societies, tribal women weren't considered chattel, which is the property word that you see in the old Anglo legal texts, sexual assault was considered a grave crime. And so Sarah Deer is really careful to say it's not as if rape was imported, that there was crimes against, there were crimes of, intimate partner sort of crimes, but they were really, really rare, and they were handled really, really seriously. And that's also important because we're going to talk about what accountability means for these kinds of crimes. So I quote a text or a quote from Sarah Deer's book where she says, "Men who cause stress in the community or risk to the survival of the tribe by dishonoring women were held accountable by the people. They could not carry the sacred pipe, nor could they hold positions of status." And so of the tribes that she studied, she found that many of them banished people if they committed crimes like rape. Some of them had corporal punishment sorts of traditions, and some of them even had the death penalty. And what this resulted in were extremely low levels of these kinds of crimes. And I think it's also just helpful to kind of understand that tribal societies had very fluid gender lines. Some of them did, and they accepted a two-spirit, gender non-conforming people. And I think that this can also play into what happened when you had these societies that had very low levels of intimate partner violence and sexual assault, and then you had colonization and just two very different systems coming into contact with each other. So I want to bring all of that history up to present day and ask the question, so why is it that Native women are disproportionately affected by sexual violence right now? And some of the statistics I'm sure we have all heard, they're pretty grave, and that's more than 1 in 3 American Indian and Alaska Native women will be raped in their lifetimes, and 2 in 5 will be victims of domestic violence. Sarah Deer characterizes the trauma of rape as an enduring violence that has spanned generations. She worked, before she became a lawyer, she was an advocate, much like the advocates that work at Safe Harbor, and she came into contact with, she was working with the Haskell Nation in Kansas with women who were the 5th generation of women in their family who had been raped, starting from having had contact with settlers, having attacked the tribes, and hearing stories of rape that happened at that point, and then rape at the boarding schools, and on down until she was the fifth in that line. And so it truly was a violence that endured 5 generations. And she really presses the point that this is not just, we hear the word epidemic, which kind of gives us the idea that it's like a sickness that just kind of hit and we don't know how to handle it. And she says it's not, this sexual violence against Native women is not kind of an epidemic of mysterious origin. We know where the origins are from, and we need to then understand that when we try to figure out how we're going to confront this problem. And I'll also now talk a little bit, I don't want to get too far into the complexities of tribal jurisdictional laws, but it is really important to kind of have a brief understanding of that, because when we do, then we can understand why Native women continue to be disproportionately affected. So from 1978 until 2013, tribes were stripped of the authority to punish non-tribal perpetrators. There was a Supreme Court case where they decided the tribes had originally had jurisdiction to punish non-tribal perpetrators, and they said they no longer wanted them to do so. And so that meant for most reservations, and I'm not going to be talking a lot about this specific reservation. Many of you may know that on the Confederated Salish and Kootenai tribes, they have entered into the Public Law 280 agreement, which means that the state of Montana has concurrent jurisdiction here with the tribes rather than the federal government, and it's the only reservation in Montana to have that status. So some of these things that I'm talking about would apply to other reservations in Montana and not necessarily this one, but some of the statements also apply to this reservation. And if you have questions about that as I go, please feel free to ask. So on most reservations and on the majority of reservations in Montana, it's the federal government who then is tasked with prosecuting crimes of rape. And what has happened is that the federal government has failed to do that. And between 2007 and 2012, the federal government failed to prosecute 50% of alleged violent crimes on reservations, including 75% of sex crimes. And that's just a huge rate of declining to prosecute. And what it has really resulted in across the nation is a culture of impunity where it becomes clear that you can go onto Native lands and you can commit a felony against a Native woman and that you will not be held accountable for it. But with the reauthorization, well, kind of, but there's with the reauthorization of the Violence Against Women Act in 2013, tribes are now able to prosecute non-Indian perpetrators of domestic violence against Native women in Indian country. And many tribes across the nation are currently working to implement these things. But the unfortunate part of that is that tribes are only now able to prosecute sexual crimes committed by non-tribal perpetrators against tribal women if they kind of arose from an intimate partnership. But if someone came onto tribal lands, a non-tribal member, and raped a woman that he did not have any ties with, the tribes are still unable to have, and the federal government would still be tasked with that, and as we see, it's very unlikely that prosecution will happen. So that means that tribes still lack jurisdiction over most rape. I think I have a typo in there. But they just have jurisdiction over rapes that would happen in an intimate partnership. And Sarah Deere explains this by explaining that Congress just didn't have the willpower to turn over Oliphant, which is the Supreme Court case that completely stripped tribes of jurisdiction. And so they just made some headway by saying, now you can have special domestic violence jurisdiction. And so many tribes are still pushing to get Congress to fully restore. And the word restoration is really important because tribes are saying, we used to have full jurisdiction to prosecute these crimes and to handle these within our tribes, and we have been stripped of that. And so it's not that you're granting us some new right to do this, but it needs to be fully restored, and that's a work in progress. Does anybody have any questions about some of those jurisdictional
What was the year that you said the partnership, that the tribes could start prosecuting again? What was the year?
So the reauthorization of VAWA in 2013 allowed that, but I think there were only 3 tribes, the Squamish, I can't remember the 2 other ones, that were able to immediately begin doing that because they qualified. But now any tribe can go through the process, which means that you'll ensure due process for the perpetrator and fulfill certain constitutional requirements. And I wanted to get an update. The last I heard from the prosecutor's office, the tribal prosecutor's office here, was that because the state of Montana, the office right there in Polson, and they work together with concurrent jurisdiction, that there probably weren't going to be efforts on this tribe's behalf to try to move to start exercising that special jurisdiction. And what that would mean is just normally the tribal court here wouldn't prosecute a non-tribal offender of domestic violence. They would just call up the county attorney's office, and that case would go up there. And it sounds like, I don't think that there's, tribal council would just have to decide if they wanted to start granting or having the CSKT court exercise this jurisdiction over non-tribal perpetrators of domestic violence. But so far, it's my understanding that there isn't an intention right now to do that.
Hilly, I'm not sure if your screen's supposed to be changing or not.
Oh, I'm just doing it here, I'm sorry. I'm way behind.
Yeah.
Sorry about that, guys. Okay, well, if you guys want to see any of the content on those last slides, I can always run back. Just kind of stepping back and looking at some general national sorts of statistics about about sexual assault. When you look at the big numbers nationally, sex offenders are overwhelmingly white males. And that's kind of an old statistic that I have there that should have been updated. A more recent one that I saw was consistent with the 6 out of 10 being white. Most sex offenders don't have a history of being sexually or physically abused, and we can talk a little bit more about this. I think there definitely are a subset who did have that victimization, and then there are another subset who probably would fall more into the acquaintance rape that we are hearing a lot more about on campuses and in all other contexts. And then I really think that the last point is just kind of goes to why crimes of sexual violence were so rare in pre-colonial tribal societies, is that we really see the rates of sexual violence decrease in communities where offenders are held accountable, and we really see the rates of sexual violence increase when it goes unpunished and untalked about. Okay, I'm going to simultaneously. And I think this is something that we're talking more and more about, and that's just sort of our changing conceptions of what rape really is, and why we're kind of grappling with understanding cases that we're hearing about at universities, and then with fraternities and football players and all of these kinds of situations where we all have family members and brothers and sisters and children, and it's uncomfortable and everybody has lots of strong feelings about it. And I think that what we do just need to start understanding as communities, though, is that rape is rarely, but sometimes, caused by the stranger assailant who breaks into the house or jumps out of the bushes. Those cases happen, and they maybe get more attention, but they are the minority of cases involving sexual assault. It most often occurs between a victim who knows their perpetrator. So among victims ages 18 to 29, 2/3 had a prior relationship with the offender. These are all National Institute of Justice statistics. And that 6 in 10 rape or sexual assault victims said that they were assaulted by an intimate partner or a relative or a friend or an acquaintance. And that among students in college, that 9 out of 10 victims knew the person who sexually victimized them. And I think that this is just, it's really important that we start to understand this, because it means that we can then respond to it. But it's something that a lot of people are having a lot of difficulty coming to terms with, because it's a hard reality knowing that a lot of sexual violence is perpetrated between two people who knew each other before. Going back to some tribal specific findings, so when we look at sort of those national statistics about acquaintance rape and just about what sexual violence looks like, the vast majority of those rapes kind of on a national general level we see happening within the same race, that they seem to be committed by the perpetrator is the same race as the victim. But for Native women, that is just not the case. And in 86% of reported cases of sexual assault against Native women, survivors said that the attackers were non-Native men, according to the Department of Justice. And a lot of the people who are studying this find this to be an anomaly in criminology. But I also think that we can really see why this anomaly exists when we understand that perpetrators are more likely to commit sexual violence when it goes unpunished, and that tribes have lacked the authority to exercise jurisdiction over non-tribal perpetrators of sexual violence. Does anybody have any questions? If not, then I'll just jump into some Title IX basics. So Title IX itself is just a big piece of federal civil rights legislation that prohibits sex discrimination in general in education. We used to hear about it a lot, I think, with like the amount of sports teams that girls get versus boys. That was how I always thought Title IX was. But I think more recently we're hearing about Title IX more because it's the avenue through which victims of sexual assault are trying to find some remedies when they're on campus, having been sexually assaulted. So it's a general prohibition against sex-based discrimination. It doesn't apply to just female students. It protects any person from sex-based discrimination. And it's supposed to address a broad range of sex discrimination, including sexual harassment, sexual violence, gender-based discrimination. But what we're going to be talking about is the adjudications that have been happening on campuses in response to the sexual assaults that... Has anyone seen The Hunting Ground here? So I think that's a really helpful documentary to watch. It will kind of help you understand how we got to these Title IX adjudications and just what's going on campuses and why we're seeing books like Missoula come out and why we're hearing more about some of these scandals across the country. So there's also there's a lot of controversy involved in these adjudications, and there's a lot of universities who haven't done them very well. I think that's really important to recognize that. And what this means, just to summarize it, is if you are a student at a university and you are sexually assaulted, you may just want to not have to see the perpetrator on campus, in your class, in your dorm, at the mess hall, wherever you might run into your perpetrator. You may feel terrified to go to law enforcement. And Title IX is designed to address those immediate needs of victims of sexual assault on campuses. So I think some people think that it's sort of like there should either be a Title IX adjudication on a campus, which is sort of an appointed panel of university employees who oversee a hearing where they decide what happened and what to do next in order to keep a victim safe. But it's not a criminal proceeding. So the worst that could happen to the perpetrator is that they are suspended or ordered to leave that school. There are no criminal ramifications. And so, and it's very different from the criminal justice system in a lot of ways, and it's kind of designed to meet needs in different ways than the criminal justice system is. And for many victims on campuses, these sorts of adjudications are their best bet. And that's because a lot of victims of sexual violence don't want to turn to the criminal justice system. because I think this can also go back to where we get our laws from and what the nature of our sexual intercourse without consent and rape laws look like. We don't have a criminal justice system that's set up to help victims very well. So from the get-go, I think many victims fear skepticism and abuse from the police and the prosecutors, and then a jury if they ever get to that point. Some may not want to go through the ordeal of a long trial, and some may fear retaliation, and others maybe just don't want the perpetrator to go to prison. They just want to be able to be on campus and not have to think about that every day. But I think it's also important to understand that even when victims of sexual assault do go to law enforcement, they often have a really difficult and negative experience. And only a quarter of all reported rapes lead to an arrest, and only a fifth lead to prosecution. And then only a half of those fifth ever really result in conviction. And along the way, it can be a really brutal process for a victim. And then there's also some just general problems with the crimes that are covered by state laws to begin with. Some state laws don't cover sexual violence that's perpetrated in same-sex partners still, but a campus adjudication could address that. And some state laws don't recognize men as victims of sexual violence at all. But campuses, unlike the state criminal justice system, are required to take up every report for adjudication and take it through that adjudication. And I don't know, I know, Kathy, that you had expressed some interest in the Title IX adjudication process, and I just only want to talk about it as much as people feel like they want to know more about it, or if there are any specific questions about maybe some of the controversies that have happened, or what specific remedies are possible. But I'll just briefly run through these, and then we can wrap up pretty soon. So I guess I'll just maybe use this slide to comment on what happens when the criminal justice system takes on a case of sexual violence. And I think what we don't always understand is that it's the state prosecuting. The state is the named party who is prosecuting an accused perpetrator. So the victim sometimes gets pushed to the sidelines, and the interests of the victims are not always taken into account. And it is just often a really, really, really shaming and difficult experience for a victim to go through this process, because they just have their entire histories dredged up and kind of every reason to undermine what they're saying sort of torn apart. So it's just it's just a really terrible process for anybody to choose to go through. And so I think that's really important that we keep that in mind. And then I also just want to say that I don't mean to just say that law enforcement doesn't take these cases and prosecutors don't take these cases because they just don't want to, and they're just not doing their jobs, and that they just don't care about victims of sexual violence. The crime of sexual violence is a different crime compared to other violent crimes. And what we're learning now is there are recent neurobiology traumatic studies that look into what happens during a violent sexual assault. And things happen that result in a victim's behavior being incredibly counterintuitive. Just doing things that you would say, I wouldn't do that if I were thinking rationally or I were in that situation. And so just some examples of these things are the victim might have, they call it a state of tonic immobility. And really what they're just starting to study what happens with the brain, and I won't get into, I'm not a neuroscientist, but just when a rush of hormones are released when somebody is being assaulted, they're finding that even though normally those hormones would make you want to fight or flee, that really in a sexual assault case it most commonly makes you freeze. To the point where there have been friends in campus-related sexual assaults who go into the room after their friend has been sexually assaulted and they can't actually move the victim's body for like 10 minutes. They're just like totally locked up. And that makes it impossible for them to do anything. And also what we find is that their memories don't encode the same way that ours might after something happens, that they're fragmented and they can't put anything together. They also find that this happens like when police officers shoot someone, and there's an officer-involved shooting. They often give that police officer like 2 days before they go in and do the full interview to see what happened, because they know that police officers experience something similar with their memories fragmenting. And so I guess I just wanted to give you a brief idea of why law enforcement is reaching out and needing so much training on this, is because they expect a victim to immediately tell them what happened. They expect a victim to have tried to punch or fight for her life. They expect a victim to do all of these things, and now the neuroscience is telling us that the victim actually usually, in a lot of cases, does the opposite. Not always, but a lot of the time. And so I think it's why it's just such a tricky area to be law enforcement or a prosecutor, because it's just not playing out in the ways that our rational minds think that it might. So, and that's also just an example of why the criminal justice system sometimes doesn't respond to crimes of sexual violence on behalf of the victim very adequately, and why these Title IX adjudications may provide a remedy that's a lot more victim-friendly than the criminal justice system. So I just want to quickly conclude. I didn't talk today a lot about dating violence or healthy relationships, but I do want to emphasize how important I think all of this kind of information is for young people. I think that understanding what healthy relationship dynamics are, what consent means, they're finding when they talk to university students that many of the perpetrators who describe behavior that is absolutely legally rape, that they don't understand that that was rape. And that a lot of the victims who are suffering from deep psychological trauma don't understand that they were raped either. And it's because we're not having conversations about what healthy relationship dynamics are and what consent is. So I don't know if we can cue up this little video. I think I can run over there and do it, Kathy, if that's easier. Well, these are just some resources that I think are really helpful for young people if you want to share them with the people in your lives. For understanding how to address these issues in the context of their high school realities or whatever age and institution that they might be in. But I like this consent video because I think that it's simple and kind of funny, and it also just sort of stays with you as a good way of thinking about what consent really means in a relationship. Okay. Does anybody have any questions?
I've heard that the biggest insurance payout for public schools is to silence those who have been sexually attacked. Have you done any research on that or heard anything about that?
I haven't personally. I guess my understanding of why campuses up until now have done very little to take seriously the sexual assaults that are happening is if the alleged perpetrators are on an athletic team that provides the school a lot of funding, then that makes it really tricky for the university. And also just being recognized as a campus where sexual assault happens is something that, makes your endowment go down. But unfortunately, universities just tried to hide the numbers and not talk about the reports that they were having, and it just kind of blew up. So I would imagine that they're probably having a lot of financial problems stemming from the sexual assault crisis, including insurance. But it really is a problem that needs to be addressed. Yep. Well, I'll take your question after we watch the video. Yeah, I'm ready.
Yes, she's ready. If you're still struggling with consent, just imagine
Well,
instead of initiating
It's not
sex,
showing up
you're
on the
making them
screen
a
out
cup of tea.
here.
You say, hey, would you like a cup of tea? And they go, oh my God, I would love a cup of tea. Thank you. Then you know they want a cup of tea.
I hope it
There we
is.
go.
If you're still struggling with consent, just imagine instead of initiating sex, you're making them a cup of tea. You say, hey, would you like a cup of tea? And they go, oh my God, I would love a cup of tea. Thank you. Then you know they want a cup of tea. If you say, hey, would you like a cup of tea? And they're like, I'm not really sure. Then you can make them a cup of tea, or not, but be aware they might not drink it. And if they don't drink it, then, and this is the important part, don't make them drink it. Just because you made it doesn't mean you are entitled to watch them drink it. And if they say no thank you, then don't make them tea. At all. Just don't make them tea. Don't make them drink tea. Don't get annoyed at them for not wanting tea. They just don't want tea, okay? They might say, yes, please, that's kind of you. And then when the tea arrives, they actually don't want the tea at all. Sure, that's kind of annoying as you've gone to all the effort of making the tea, but they remain under no obligation to drink the tea. They did want tea, now they don't. Some people change their mind in the time that it takes to boil the kettle, brew the tea, and add the milk. And it's okay for people to change their mind. And you are still not entitled to watch them drink it. And if they're unconscious, don't make them tea. Unconscious people don't want tea. And they can't answer the question, do you want tea? Because they're unconscious. Okay, maybe they were conscious when you asked them if they wanted tea. And they said yes. But in the time it took you to boil the kettle, brew the tea, and add the milk, they are now unconscious. You should just put the tea down. Make sure the unconscious person is safe. And this is the important part again. Don't make them drink the tea. They said yes then, sure, but unconscious people don't want tea. If someone said yes to tea, started drinking it, and then passed out before they finished it, don't keep on pouring it down their throat. Take the tea away. Make sure they're safe, because unconscious people don't want tea. Trust me on this. If someone said yes to tea around your house last Saturday, that doesn't mean they want you to make them tea all the time. They don't want you to come around to their place unexpectedly and make them tea and force them to drink it, going, but you wanted tea last week. Or to wake up to find you pouring tea down their throat, going, but you wanted tea last night. But if you can understand how completely ludicrous it is to force people to have tea when they don't want tea, and you're able to understand when people don't want tea, then how hard is it to understand it when it comes to sex? Whether it's tea or sex, consent is everything. And on that note, I'm going to go make myself a cup of tea.
So I think that's just kind of a brief example of helpful tools to start that conversation, because they're hard conversations. I think that when situations in Missoula came up on the campus, it was uncomfortable to talk about it with friends and with family, and acquaintance rape. It's especially when it involves people who are high profile and are in positions of status, and it's just not easy. So I think that that's also something that we can get out there up front before we start these conversations. And I'm happy to always be a resource if anybody wants to reach out. There's my information, and if anybody has any questions right now, I'm happy to take them, and you can also reach me in other ways if you'd rather not ask me right now.
Hilly, I converted all those slides to a text file, so if anybody needs that, where you signed in tonight, put a star by your name, and if your email is on there, I can send you the text file, so you have the whole text from all the slides, the whole program. I didn't make copies because I didn't know how many people would be here, that would need them, but if you need it, especially for the certification, let me know.
Did you have a question earlier?
So the school can still do their adjudication, and then you can also still have criminal charges
Yes.
running concurrently. right? So you could still do both. And then, it's my understanding, so if a student reports an assault but does not want to pursue the Title IX, the school will still look into making sure that the student body at large is not at risk from the potential perpetrator, correct?
Yeah, I think Title IX requires the campus to take action in that sense, but I don't think that they would follow through with like a hearing if the victim decided that they didn't want that remedy.
But they do their due diligence to establish safety. And it's all colleges and universities.
They are all obligated to do it. I think that there are varying levels of compliance, and then we've seen, I think, there was sort of an immediate effort by some campuses to respond with these adjudications, and then I think a lot of the adjudications didn't go very well in terms of what level of, and I don't think they have to use the term due process in that context, but sort of the Title IX adjudication version of that. I think that's where a lot of the controversy has come from, is some of them weren't handled very well.
The hunting ground was recently on CNN, and I did, for my own use at home, I have a copy that I've watched. And if you can get a hold of a copy, I would recommend it. If you're a young person thinking of going to college, because it's very informative and really goes through the process. And we know because it happened to a friend of ours on a college campus, and it's a scary thing. So protecting yourself is the aim of this whole program tonight.
All right, if there aren't any more questions, then I'll hand it over to you, Kimberly.